Background of Marbury versus Madison. An election happens and someone gets their butt kicked. In the intervening time between them getting kicked out of office, the lame duck period, and the new administration taking power, Adams makes a slew, John Adams, the individual lost, makes a slew of judicial appointments. He makes one appointment to this individual, John Marbury, and John Marbury is appointed DC Justice of the Peace, a very low-level judicial position within the District of Columbia. So he makes this appointment and gives it to his Secretary of State and says, hey, take care of this. The Secretary of State doesn't. The Secretary of State kind of, I don't know, fails to deliver it. So Jefferson, who won the election, takes office. And his Secretary of State, Madison, finds this undelivered judicial appointment. And Jefferson orders Madison not to deliver it. And so Marbury, in this case, sues Madison as Secretary of State and sues requesting that he deliver the appointment. Madison, of course, does not, and we get said case. Now, when did the election happen? Did it happen in 1803? No. So why did it take till 1803 for them to hear the case? Because upon Jefferson taking office, he ordered that the Supreme Court march circuit or ride circuit. It's the idea of where we get the circuit courts of appeals from. Because a circuit means literally a track. And judges from the U.S. Supreme Court had to ride the circuit, literally hearing cases. So basically, Jefferson cancels the Supreme Court for a number of years, 2 years. This is one of the first cases they hear when they get back. There's another appointment that happens during this time. So while Adams is doing this slew of judicial appointments, he makes one more. And that's to the Chief Justice of the United States Supreme Court. He nominates an individual by the name of John Marshall, Chief Justice Marshall. Chief Justice Marshall had a different title before he took the Chief Justiceship, and that was Secretary of State. So the individual who becomes the Chief Justice is also the individual who fared to deliver the appointment to John Marbury. So the individual who ultimately becomes in charge of deciding this case is the individual who started the conflict in this case to begin with. And that's why we don't worry much about recusal, is because there's no one who could have told John Marshall to recuse himself except John Marshall. Let's get a little bit more fine detailed. What are the issues in this case? There are three. First, does Marbury have a right to his appointment? Second, does law provide for a remedy for this right? And third, does the Supreme Court have the authority to issue a writ of mandamus? Now, hold on. What is a writ of mandamus? Well, a writ of mandamus is an order from a court compelling an individual employed by the government to do their job. In this case, the order would be from the United States Supreme Court compelling the Secretary of State to deliver the memo, to deliver the appointment. So, does Marbury have a right to his appointment? Does the law provide a remedy for this right? And does the Supreme Court have the authority to issue a writ of mandamus? So, how does the court decide? Answering questions in order. John Marshall says that, yeah, of course, Marbury has a right to his appointment. It was signed and sealed, and it simply failed to get delivered. That delivery is secretarial. The signing and sealing of it is actually an act of government. Delivery is not an act of government, but signing and sealing something is. And so the mere fact that this wasn't delivered does not take away the official nature of this order. It is simply something that prevented him from receiving, but it does not deny him his appointment. Second, is there a law that allows him to redress this? Well, of course, if individuals' rights are violated, it's the duty of society to provide a remedy for that right, and there actually exists a remedy for that right. And the remedy for that right, in this case, very clearly would be a writ of mandamus, which is what Marbury has requested. He's requested from us a writ of mandamus. So, the last question, does the Supreme Court of the United States have the authority to issue writs of mandamus? And John Marshall here says, well, no, we don't. And the reason why we don't is pretty particular. And says that the Supreme Court can't issue a writ of mandamus in this case because the Judiciary Act of 1789, which Marbury used to ask us to send a writ, is unconstitutional because it alters the Supreme Court's original jurisdiction. So you see, Congress passed this law in 1789 called the Judiciary Act, and among other things, it said that the Supreme Court can hear, in the first instance, issues involving writs of mandamus. Well, the problem is the Constitution, Article 3, spells out very clearly what the Supreme Court's original jurisdiction is, meaning that these are the types of cases they can hear originally, first. And Congress made a law that said, oh, there are these other types of cases that the Supreme Court can hear originally, one of them being writs of mandamus cases. And so John Marshall, the Chief Justice, says that, well, despite the fact that this individual is due his appointmentship, there exists a legal remedy by which to provide it. We can't provide it right now because John Marbury came to us directly using the Judiciary Act of 1789, and that Judiciary Act of 1789 that gave him the authority to do that is unconstitutional because it attempts to modify the Constitution. And therefore, this whole case collapses because John Marbury did not go to a lower court before he brought his case to the Supreme Court. This should sound trivial as hell, because in the big picture, the story of the case is absolutely trivial as hell. No one really cared if John Marbury got his nomination. That wasn't what was going on here. What was going on here in a much bigger and broader sense was a battle of power between the Supreme Court and the Jefferson administration. And what John Marshall, the Chief Justice, did in this particular case was give Jefferson and the Jefferson administration exactly what they wanted while taking something for himself. And giving the Jefferson administration exactly what they wanted was their ability to not deliver this appointmentship and a few others that also fell in the same vein. So Jefferson did not have to deliver these appointmentships, which meant that he would be able to nominate individuals into these positions. But Marshall carved out a little piece of something for himself. Marshall, in the way that he decides the case, says that, well, the Supreme Court has the authority to declare acts of Congress as unconstitutional, to engage in what commonly becomes known as judicial review. And so even though in the short term he gives Jefferson and the Jefferson administration exactly what they want, he does so in a fashion by which he carves out the right of the judiciary to actually do stuff. Because before the judiciary gets the authority of judicial review, the judiciary, the Supreme Court really wasn't doing a whole heck of a lot because they couldn't. But now the United States Supreme Court becomes player and becomes a very powerful player in that they can declare acts, they can review acts of Congress and let Congress and the executive branch and potentially declare them invalid. But the thing is, the court doesn't do it all that often. They understand that they have basically a nuke in their arsenal, and they very rarely deploy said nuke. In this case, it didn't matter. They were declaring a law invalid that was passed over 10 years ago, and no one really cared. They weren't offending anyone. It was an act about the judiciary, and it was the judiciary itself deciding it. No big deal. Well, when's the next time that the United States Supreme Court uses the authority of judicial review to declare an act of Congress unconstitutional? That case is Dred Scott. And one of the primary motivators to what starts the Civil War. So courts kind of know that this judicial review is a big deal and potentially very dangerous. So despite the fact that Congress gets this authority, or that not Congress gets this authority, the Supreme Court gets this authority, they don't use it very often. Did this definitively grant the Supreme Court the authority of judicial review simply by the precedent of this decision? Sure. Also, no one else really fought it. That's kind of the brilliance of Chief Justice Marshall here. Chief Justice Marshall made a decision that Jefferson absolutely wanted, but did so in a fashion by which he got something himself. So the only way for Jefferson to disagree with this decision was to recognize that the other 2 points, that John Marshall had a right to his appointmentship and the correct remedy is a writ of mandamus. If Jefferson disagrees with point 3, then points 1 and 2 stand, and Jefferson loses what he wants. So is this a definitive grant of power? Yeah, because no one really challenged it. There were critiques of it throughout the country, but the court didn't really use this power. It did over state legislatures. It did over state executives. And I can provide plenty of examples for that, but it didn't over Congress and it didn't over the president. So it wasn't thought to be that dangerous of a tool until you get to Dred Scott. And then it proves, wow, holy cow, it's a dangerous tool. But now the Supreme Court has been using it for 40, 50 years, and you really can't unring that bell. So yeah, this is the case that pretty much definitively gives the authority of judicial review to the United States Supreme Court. And so the place where the Supreme Court gets the power that we think the Supreme Court has is them giving it to themselves and John Marshall simply carving it out for himself. So yeah,